alley rather than how much what was done locally, you know.
It was right behind the
Good evening. Welcome to the November 30th, 2015 Board of Appeals open meeting. I'll take a second to introduce everybody and ask the public to silence your cell phones in the meantime as well. I will introduce the board. To your far left is Ken Foreman. He is vice chairman of the board. To my right is TJ Hurry. He's the clerk of the board. Next in line is Ed Van Kuren. He's a regular voting member. To his right is Paul Murphy. He's a regular voting member. Sri Budrow is at the end. She is the zoning administrator. And Mark Dabrowski is also present. He's special counsel to the zoning board. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town and considering requests for special permits, variances, and appeals as provided in the bylaws, which have been approved by town meeting and the Attorney General's office for the Commonwealth. Tonight we just have open meeting. So the two matters that we'll be discussing are appeal number 6815 and appeal number 7015. The public hearings on both of those matters have been closed. So we won't be accepting any more testimony. This is just for us to discuss what's been submitted already. I would also just like to ask anybody videotaping if they could, or recording, if they could just identify themselves at this time.
John Carlton-Foss,
Thank you. Could you just provide your address too for the record?
80 Church Street, Woods Hole.
Thank you. Anybody else? No? Okay. All right. So we should start the discussion.
I sent you an email today through Sri on the chair, and it's filled with questions about Win 2, but we have one remaining issue with regard to Win 1. If you remember the framework here, Attorney Seni filed two individual appeals, one for Win 1, one for Win 2, seeking enforcement of the zoning. We have already decided his Win 1 matter some weeks ago, and that was, we concluded that. Mr. Watt took a different procedural step here. He appealed both in the same letter. And so we've not yet deliberated his Win 1 portion of his appeal. And then, of course, going on to Win 2, the second portion of Mr. Watt's letter was about Win 2, and Mr. Seni filed a separate Win 2 appeal. So I guess the easy question for the evening, or I'm thinking that it might be easy, is what do you want to do with regard to Win 1? Do you want to simply do what you've done already, or is there some reason why you would want to, in the context of the Watt appeal, why you would want to re-examine that question in any way?
I mean, I know I'm comfortable moving forward with what we had done previously.
I am as well.
We have,
Sure.
I don't think there's been anything submitted to change.
Yes.
Why don't you have somebody make a motion to that effect? Of course, it would be also subject to Mr. Suso's letter of October 6th with protocols for maintenance during the shutdown period.
That would include that.
I would include that this time in the decision, so I don't have to write another letter to Lottie.
Yeah. We go along with that.
So does anybody
Make
want
a
to?
motion.
So that was Mr. Van Kuren.
Sure.
Do you want to elaborate on what that actual motion would be, please?
So that is application number 6815 as to Win 1, that we deny, wait, no, sorry.
Hold the appeal, right?
Uphold the appeal.
And request that they cease operation.
Yes.
Which they've done already. So I would take the material that has already been framed as the decision for Win 1, and I would put it into the first half of the decision, the Win 1 portion of the decision on Mr. Watson.
Include the partial maintenance.
Okay, so Ed made the motion. Is there a second?
Second.
Okay, so that was Mr. Van Kuren and Mr. Murphy. All those in favor?
Aye.
And I'll vote against on this one as well, since that's what I did.
So 4-1.
Okay, with regard to Win 2, slightly different, quite a bit different procedural posture. Win 1 already gone through the appeals court by the time you made that decision and reiterated it tonight. Win 2 has not gone to court at all. So we first of all have to ponder whether or not the parties that were identified by Mr. Senni and Mr. Watt have standing. And this is a matter that sort of sits with the case all along. Standing can be raised at any time. It can be raised at the Board of Appeals. It can be raised at the trial level. It can be raised by the appeals court. It can be raised by the court without any lawyer pointing it out. And typically, I would call standing is equal to the aggrieved person status. In order to file an appeal under sections 8 and 15, you have to be an aggrieved person. So an aggrieved person typically is somebody who suffers a harm or an injury, which is different than that suffered by the general public. And a typical injury would be traffic drainage. In this context, it would be noise or flicker, more particular to the type of activity being conducted. So think about who the people are before you in both the Senni and the Watt appeals, and ask yourself with regard to each of them, do they have a particularized injury of the sort protected in your ordinance, or, I'm sorry, your Bible?
Anybody want to start a discussion on that?
Let me just put these in a proper framework. All these questions that are at the beginning of my email to you are threshold questions. If they trip up on any of these, then we don't get to the merits of the decision, should we enforce.
I mean, it's my position that these folks that are being represented by the two attorneys have standing. I wouldn't want to, I really wouldn't know. I'm going to assume that they have standing. I'm going to assume that they have standing because, I couldn't pinpoint that they don't. I personally would stay away from that personally. I'm more comfortable with, a judge making that determination. So my position is I'm going to assume they have standing.
Okay.
I don't want to be the judge of that at this level.
So, I mean, my view is they have proximity, right? That's the first criteria you might apply there. There's been testimony that they're impacted by flicker and noise. To me, that's justification for considering that they have standing.
Right, and I know at the last hearing there was some question raised by the town as to Neil Anderson specifically, if he was more affected by Wind 1 versus Wind 2, and we definitely heard testimony that he is affected by Wind 2, and he does have the proximity, like Ken said, so I think it would be premature to say that they don't have standing at this stage. So.
Yeah, I would call to your attention that section 240-166 does create an interest in being free from television interference, ice throw, prop throw, noise, etc. So that is a claim that they can make for standing. Obviously, if they got green cards in the mail with certified mailing for the public hearing, they have a presumption of standing. It recedes, the presumption recedes if the issue is contested. It's always their burden, however, to prove that they do have that particularized injury. It's not the town's burden to prove that they don't. It's their burden to prove that they do. So keep it in that framework as well.
Anybody else add or TJ?
I mean, I generally agree with you and what Ken said about standing.
Yeah, I mean, that's an interesting point Attorney Grabowski brings up, that they were on the mail, at least for some of these mailings, they were on the mailing list.
The only mailing list that counts for the presumption is the assessor's list that went out when Cerise sent the notices of the public hearing. That would make them parties in interest under Chapter 48, Section 11. A party in interest is an abutter of an abutter within 300 feet, or a person who is across the street directly from the project. Sometimes the assessors err and send out many more notices in the interest of caution, but the party in interest standard for standing is abutter of an abutter within 300 feet or directly across the street. That's what the statute says. It's sometimes people more distant have standing. the, well, the cases in which people 8 houses away, so they don't qualify under that definition, nonetheless still have standing. Parties seeking to uphold the integrity of the district in which they reside have standing in some cases, but I don't think any of these parties reside in the district because it's a public use district. It's not a question that goes away with your decision tonight. Like I said, even if you decided unanimously that they have standing, it doesn't mean that the town can't raise the issue in court, and that it won't be litigated again in some other court.
Right.
Do you want to move beyond that, or are you all comfortable with that?
Is everybody comfortable?
Yeah, I'm comfortable with that.
Ken, you sound comfortable? I think
Yeah.
you're comfortable.
Want to do it on a motion?
Sure. Does anybody want to make a motion to that effect, that the parties before us, we find that they have standing?
I'd like to make a motion that the parties before us have standing.
Okay, that was Mr. Murphy, second?
Sure.
Okay, and Ken. So all those in favor?
Aye.
Aye. Unanimous.
Okay, now we're down to the beginning of the time period in which an appeal might have been filed. My understanding is that the building permit for Wing 2 was issued in March of 2010. If I remember the dates, it was March 18th, and Wing 1 construction started? It had to have been construction. Started 5 days later on March 23rd. So the Gallivan case, which was brought to your attention, was one from Wellesley in which the town has a peculiar requirement that when a building permit is issued for new construction, it goes out to the neighbors. Otherwise, the State Building Code and the Zoning Act do not require notices of building permits to be sent out. And the court ruled in the Gallivan case, when you got notice and you didn't appeal within 30 days, you lost your rights. Otherwise, you would have rights under the 6-year statute of limitation that's set forth in Chapter 48, Section 7. So the alternatives then are pretty clear-cut. If you have notice of the building permit, in the Wellesley case, you got it because it was sent to you by the town, unavoidably, then you lost your 6-year rights to seek enforcement. You don't have 6 years to appeal the building permit. If you don't do it within the first 30 days, it's the other side of the same coin. You can seek zoning enforcement. That building permit should have never been issued. Just enforce the zoning. But if you had notice in that 30-day period, you had to take advantage of it and file your lawsuit. So that's the first case. The second case is Connors. In the Connors case, the person in question was in town hall, and somebody said, hey, the building permit was issued for the guy next to you. I think he lost some portion of the 30 days already. If I remember correctly, it was on the order of a week or 10 days going by. But instead of appealing in the time remaining in the 30-day period, he waited until it was over, and then he appealed 10 or 12 days after. And the court said, you had notice, you had to appeal. The third case is the Richardson case, in which she followed his building permit activities for the better part of a couple of years, had gone to Conservation Commission hearings, and pretty much was an interested party in terms of what was going on next door. But she waited and didn't appeal the building permit in that 30-day period. And the court said, you had, as a person of interest here, a duty to inquire, and you basically didn't do it. And so therefore, your 30-day period is gone. You don't have the 6-year statute of limitations. So you have to try to decide what happened. All we're focused on right now is the 30-day period from March 18th to April 18th, plus or minus a day. And the question is, should they appeal the building permit within that period? It's not about when they knew, did they appeal it within 30 days. It's about the first 30 days. That's all that this question is about.
So, but that hinges, if I'm understanding, they have to have knowledge.
Yes, they have to have notice. Either they have to have actual notice or legal notice because somebody sent it to
So in the
them.
case of Okagawa, I was quite convinced that by the affidavit, her testimony, that she didn't have knowledge. And she was upfront that when one had no she had no issues with Win 1, and why would she suspect any further problems? For me, that was, for the first 30 days, it was clear.
Yeah, I'm assuming they didn't know either. I deal with this a lot. I think the general public is you know, generally kind of ignorant to this stuff. They're not aware of permit process and appeals, and they wouldn't have known that. And so I'm just going to assume also that they didn't know that the building permit was issued. Within, you know, within 30 days, that they have direct knowledge of that. I would say probably, if they're representing that they didn't, I would say that's probably believable. I see it a lot in what I do for a living, where